During the fourth week of our session, that was last Saturday, we considered part of the presentation that I was doing on the previous week. That was on the Banking Act, and then last week I continued into uh, started the presentation on AML and CFT, anti-money laundering and combating of financing of terrorism, as well as discussion on financial transactions reporting. There, you might remember, we were discussing the general description of anti-money laundering, what is generally known as anti-money laundering in day-to-day literature, in the banking and financial sectors and so on. Then we went into discuss certain technical aspects of money laundering. As to what is technically meant by money laundering, although we use that term very casually, sometimes we may not look into the topic and see what necessary components are there, what kind of a transaction could be an attempt to money laundering, and so on, were discussed in a practical point of view, where we discussed that money laundering process would involve three separate components which may not be very easily identifiable in certain circumstances. These three steps were known as placement, layering, and integration. We understood how placement is done in different ways in different economies, different financial systems, and how those things are then layered by the uh, uh, masterminds behind the transactions, as well as those who have been used as their agents also, how they are using layering techniques, and then finally how money gets into the formal system, which is called formal system as with the appearance of of licit property, licit money, legitimate money, and we described how it is happening. And we had a kind of a very cursory remark on terrorist financing as to what it means and how it can happen in whichever way, what are the ways in which it could happen in countries. Having said that, I told you that I would go into the legal position since we are discussing the legal aspects of banking and finance here. From a legal point of view, what money laundering would mean and what are the things that would entail the offense of money laundering, what are the things that a bank should be careful about, those things would be covered in today's presentation. Probably I might take some time to describe these slides, or else I might very likely I might be able to conclude these sessions and go into a new topic as well. I'm sure Menaka will share with you the presentation slides I sent him a few minutes ago. So I'll go into the legal position in Sri Lanka with regard to AML and CFT. The legal position in Sri Lanka consists of three elements mainly, which are Prevention of Money Laundering Act number 5 of 2006. Then you'd see that, as name denotes, it is a statute that deals with the prevention of money laundering. Then we get the other statute dealing with financing of terrorism, which is Convention for the Suppression of the Financing of Terrorism Act. And then the third statute, which is Financial Transactions Reporting Act number 6 of 2006, which acts as some sort of an overarching structure which joins substantive laws mentioned earlier. Prevention of Money Laundering Act, while it deals with anti-money laundering. Convention on for the Suppression of Financing of Terrorism Act deals with offense of terrorist financing. The third statute, which is the Financial Transactions Reporting Act, it's an overarching structure which kind of encompasses the scope of both PMLA as well as the Convention Act, where reporting structures, administrative arrangements, and so on are provided in the third statute, which is Financial Transactions Reporting Act. You, being the professionals connected to the banking and financial sector, very often you are coming across with the situations pertaining to the third statute, because AML and CFT are substantive things that are supposed to be determined by courts and regulators, as the case may be. But from a very practical point of view, the area where you come into play, area where you need to be active and you need to be vigilant, is the third statute, which is the Financial Transactions Reporting Act. We'll go into these statutes. I will not discuss Convention for the Suppression of Financing of Terrorism Act in detail. I'll mention you the reason why we don't have to go into that, but I'll take on other two statutes in detail. I think I will first mention why I'm not going into very much into Financing of Terrorism Act. The reason is that the definition, as I told you last week, is very much connected to the definition of terrorism. You'll see that this name of the statute is also different. The reason being, it talks about the International Convention for the Suppression of Financing of Terrorism Act. There is one particular thing about any country's legal system. That is, when there are norms in the international law, in certain countries, those laws become necessarily a part of the domestic legal system as well. That kind of system is not there in Sri Lanka. I think most of the countries, a larger majority of the countries in the world, are having a thing called a dualist system, where international law does not become necessarily part of the country's domestic law unless the domestic legislature enacts such legislation to adopt the international convention. Now, Sri Lanka is a place like that. You may remember famous things like certain laws related to hijacking, say Palaikanayaka incident, where Sri Lanka did not have a provision, did not have laws to deal with hijacking. But Sri Lanka was a party to an international convention which aims at preventing hijacking. On that basis, Sri Lanka wanted to enact a law. Sri Lanka enacted and did certain things, but that's a different thing. Now, that's a good example. Sri Lanka, even though Sri Lanka as a country signs certain international conventions, they don't become Sri Lanka's law. They don't become part and parcel of Sri Lanka's domestic law unless and until the Parliament of Sri Lanka enacts a law adopting that international convention. That is what is meant by a dualist country. So Sri Lanka has been a signatory to the International Convention for Suppression of Financing of Terrorism. Even though we have been a signatory, that did not become part of Sri Lanka's law until such time Sri Lanka enacted a law to adopt that convention. Now, you may have heard recently of ICCPR law, International Convention of Civil and Political Rights, right? Now, that is that Sri Lanka has been a signatory, but certain provisions, those conventions, the contents of those conventions become operative in Sri Lanka only with Sri Lanka's parliament enacting a law. So, largely, the second statute I'm mentioning here is something like that. It basically adopts the international convention and introduces certain limited provisions to give effect to the convention. Other than that, I don't have to go into something afresh because it's international convention almost, right? Whereas in the first statute and the third statute, there are a lot of domestic components. So I'll discuss first and third statutes in detail. Prevention of Money Laundering Act. This is, as you see, that this law was enacted in 2006. The Speaker signed the law on 6th March, and this was subsequently amended by Act number 40 of 2011. You would see the objectives of the Act, as given in the Act, are to provide the necessary measures to combat and prevent money laundering, and for matters connected therewith and incidental thereto. A very short description is given there. Uh, Now, before going into the next slide, I would discuss certain other things that probably uh, I would need to discuss in the discussion of these substantive provisions. When I was dealing with the general description, you may remember we talked about serious crimes. Serious crimes meaning the money laundering was considered as a process which is related to hiding or kind of suppressing the illicit origin of money obtained from a serious crime. That is how I explained there. Then I mentioned that these serious crimes may be described in Sri Lanka's statutes as well as in other countries in different terms. In Sri Lanka, we use the term unlawful activity in both PMLA as well as in FDRA. Before that, I need to tell you something. You know that in a criminal in criminal laws, generally we recognize things as offenses. වැරදි කියලා අපි සිංහලෙන් කියනවා. What are these offenses? Now, if you take the penal code, theft is an offense. Homicide, killing somebody is an offense. Rape is an offense. All these are offenses. Say, we'll come to some financial related things. Bribery is an offense. Insider dealing in terms of SEC Act is an offense. Banking, under the Banking Act, you may remember things like, say, breach of secrecy. Those are offenses. Now you would see that these offenses are there to achieve some sort of a social objective, that is to prevent people from doing certain acts which are harmful to the society. If you let people to kill others, that is not good. Society cannot go on like that. Theft is bad. That is why it has been defined as an offense, right? Fraud, say cheating, criminal misappropriation of funds, all these things are offenses. When a prosecutor wants to prove these offenses, right, they have to come up with evidence to show that these elements of the offense have been are there, therefore offense has been committed by a person. Now those are standalone offenses. If the charge is theft, what the prosecution has to prove is that this man has done these activities. There are several components of theft, and thereby has committed the offense called theft. This man has done these things, and thereby has committed the offense called bribery. Now these are kind of a straightforward prosecutions, and someone who is found guilty, who is if the charges are proved, the person who is found guilty will be punished by a court. The money laundering offense, the offense called money laundering, is different in this sense. Money laundering is not, it's a standalone offense in the sense that it can be proved like that. But money laundering always goes along with some other criminal activity. Now, as I told you, if someone is trying to hide the illicit origin of money, since money has been obtained from a crime, now the process is also an offense. That process is called money laundering. But as the definition goes on, as that general definition goes on, that money has been obtained from a crime as well. So we can call this money laundering kind of a derivative offense. It is derived from some other offense. Now I'll give you some examples. Just imagine a drug dealer selling certain prohibited items, drugs, narcotics, right? Now, selling narcotics, selling that thing and having even in the possession of the having drugs in possession, those are offenses. For those offenses alone, one can be punished. But if someone has earned money out of those offenses and using them to hide the origin of that money, that is called money laundering. That again is an offense. So you'll see that this is a derivative offense in the sense that it has derived from the earlier offense called drug trafficking, whatever, possession of drugs or whatever. Someone who has, say, earned money by killing somebody for a payment, some sort of contract killing, has committed a crime. Homicide, killing someone is a crime. Now, he has obtained some money for killing someone and using that money in a particular way to hide the illicit origin of money. That second process of hiding the origin of money is called money laundering. That is also an offense. Homicide, the killing of the person, is also an offense. A person who is sending Sri Lankans to, say, Australia by boat is doing an offense under immigration law. Now, having done that, if he is using that money to hide that illicit origin of that money, he is using that money in the financial system in such a way that he wants to hide the origin, then that process is again an offense. That is money laundering. So you see that while this money laundering offense is there, there is some other offense, connected offense is also there. In AML-CFT related literature, very often we call them predicate offenses. Predicate, predicate offense, right? Predicate offense means in that is the fundamental offense. That's the main offense someone has committed. Derived from that, there is a process of hiding the wealth originated from that offense. Now, that is how money laundering is identified very commonly. Now, why I said that is to connect that to certain provisions of the PMLA while we go on. This act would apply to any person who commits an offense under the provisions of this act whilst in Sri Lanka. Right? And an institution which is used for commission of an offense under the provisions of this act, which institution is carrying on business in Sri Lanka and is either incorporated or registered in Sri Lanka, or is either incorporated or registered as a branch of a bank, incorporated or registered outside Sri Lanka. This is very technical definition given in the act. An act which constitutes an offense under this act which is committed in Sri Lanka. The institutions that would cover under this law, PMLA, are given here in section 35. Any person or body of persons engaged in or carrying out any finance business. Here, the meaning of finance business is not what is referred to in Finance Business Act. This has a different meaning. This finance business would mean banking as well. Then there is a second category of institutions which we deal with here under this law. Those are designated non-finance businesses within the meaning of the PMLA. So you'll see that financial institutions as well as certain designated non-financial institutions would be covered by this law. Finance business, as I told you, is not only that what is coming under Finance Business Act, but all these things are covered. Banking as defined in Banking Act. So if you are a banker, you are directly coming under this scope. Finance business as defined in Finance Companies Act. Sorry, this is not Finance Companies Act was earlier there in the law. Finance Companies Act number 80 of 1988, if I can remember correct. Now it is Finance Business Act number 42 of 2011. Any institution license under that is coming under finance business. Lending institutions, including consumer credit, mortgage credit, etc. Those who are doing factoring, finance leasing, other than transactions related to consumer products, the transfer of money or value. Money value transfer systems are recently made very strongly regulated under this. There are certain other entities like money and currency changing services, issuing and managing means of payments, right? That is checks, money orders, etc. Issuing financial guarantees and commitments. Uh, this kind of trading given in item 9 here. Several other things: participate in securities issues and provision of financial services. Any company licensed under license to carry out banking business. Uh, Cooperative societies, Samurti related entities, those are there. When it comes to designated non-finance businesses, uh, individuals and collective portfolio management, those are doing that. Invest in, administrate several professional, several entities which can be vulnerable to money laundering transactions, but not really in financial institutions, are identified as designated non-finance businesses. You see this item: lawyers, notaries, and other independent legal professionals. Uh, you'll see this reason why this long list of businesses are there. I told you that even a professional can be an intermediary who can be used to layer kind of a financial transaction. Uh, Property transaction may not be done between the negotiations may not be done between the real owners, but professionals may get involved. Now, in those circumstances, probably the illicit origin of the source may not be very visible. Now, probably you may remember in about 5-6 years ago, a famous or ill-famous drug dealer was being sued, and I think he's still in remand prison. Uh, there were circumstances where actresses were summoned before courts. Actresses came and gave evidence. The reason being, these actresses have acted as the agents of the drug dealer. You see in Sri Lanka, these certain things which are recognized elsewhere as very, I mean, the involvement of intermediaries like professionals are well known. But in Sri Lanka, it takes another form as well. This kind of people are also being used. That is why designated non-financial businesses are covered. I think you can just have a look at the list. That's it. I'll go into really important part, which is the offense. This is how the money laundering offense, the offense of money laundering, is defined in Sri Lanka's statute, Prevention of Money Laundering Act. Uh, you can have a very careful look on this particular slide and try to understand what it means. I'll take you through the provisions, but just have a careful look for 1 minute or so. I think you may have had a sufficient look at the provision, and also I would like to do something else which just came into my mind. I discussed this with IBSL recently. Uh, uh, that is, now we have been into this course for last 4 weeks, and today is the fifth day. I think we have come to the midpoint. Uh, but still, I haven't seen any of you. Even after this course, I think those who are joining from different institutions and different backgrounds may not know each other. I mean, this kind of a course is not just meant to learn something, but that interaction is also very important in the financial sector, especially. So, I would like you to speak a little today. Probably, if I go into the next topic, I'll let you join a small discussion. There is a kind of a several points I would share with you. It's not necessarily that it would not necessarily contain a right answer or wrong answer, but certain things need to be discussed with you. Probably, I would like you to switch on the cameras as well when we go into that. So before that, I'll give you a break midway so that you can get ready for the camera session as well, right? We'll do that after the break. Now, in this section, uh, what is said is that any person uh, who engages, right? Now, it talks about a person, right? It's the focus. This is little complicated, but I'll give you the meaning after going through this. This is a statutory provision. I need to reproduce it and explain. Any person who engages directly or indirectly. Now, this person engages in something directly or indirectly. What is the thing he's engaging in? In any transaction, what kind of transaction? In relation to any property which is derived or realized, again, directly or indirectly, from any unlawful activity or from the proceeds of any unlawful activity. So there is a person who deals with, right, who engages in a transaction in relation to a property. This engagement may be direct or indirect, but he is engaging into a transaction. In any transaction, this transaction is related to a property which has been derived or realized directly or indirectly from something. What is that something? It is either an unlawful activity or from the proceeds of an unlawful activity. Now, someone has committed a crime. From that crime, he has got a property. That property is going to be the subject matter of a transaction. The person who engages in the transaction directly or indirectly is described here as the person doing the offense. I'll go to the offense part later. But what it tells you is that there is a person who engages in a transaction directly or indirectly with regard to a particular property which has been derived or realized from an unlawful activity. Or this property could have been derived from the proceeds of an unlawful activity. Now we'll start with the last two the clauses. It is derived from any unlawful activity or proceeds from any unlawful activity. Meaning that probably someone may have committed a crime. Someone may have committed an unlawful activity, say bribery. As a bribe, one may have received a car. A public officer who is doing a public duty, for doing a public duty, has obtained a car from some businessman. Now this man has committed an offense. There is a property derived from that offense, right? What is the property? That car. offense is bribing. Bribe is the offense. The property derived or realized from the offense is the car. Or else, this man may be receiving money. That again is proceeds uh, coming from that unlawful activity. Or else, he may have got the car and he sold the car and got money. Right now, that is kind of uh, that is some sort of a property or proceeds of an unlawful activity. Now you see, in relation to any property which is derived or realized directly or indirectly from an unlawful activity or from the proceeds of any unlawful activity. You may have got the property directly from the unlawful activity, or you have got some proceeds from the unlawful activity, and using that property proceeds, you have obtained a property. Whatever it is, if you are having that kind of property and engage in a transaction with regard to that, that is what is described in this first part. That kind of a person is going to commit offense. We'll come to that later, right? So if there is a drug dealer who has sold certain narcotics for a quite some period of time, he has got a lot of money. Now he is having a luxury vehicle. Now he is going to sell that vehicle. You are going to buy that vehicle, right? The fact that you as a person is going to engage, not going to engage, if you are engaging in that transaction, if you have engaged in that transaction of buying his property, then since the property has been derived or realized from an unlawful activity, which is drug dealing, you are coming within the scope of this section. You are committing an offense. When I'll explain that later. The second limb says it is common. The common part is there. Any person who receives, possesses, conceals, disposes of, or brings into Sri Lanka, right? Receives, possesses, conceals, disposes of, or brings into Sri Lanka, transfers out of Sri Lanka, or invests in Sri Lanka any property which is derived or realized directly or indirectly from any unlawful activity or from the proceeds of any unlawful activity. Here again, it can be related to a property derived or realized from an unlawful activity or proceeds of any unlawful activity, right? That kind of a property is being received, possessed, concealed, disposed of, or brought into Sri Lanka, or transferred out of Sri Lanka, or invested in Sri Lanka. Now you got money. Yeah, someone has got money from an from an unlawful activity like drug trafficking. Now, having got that money, he is trying to use that in something. You receive that money for some reason, right? Maybe as a banker, you receive that money. You possess that money, or you conceals, you hide that money. You disposes of that money. පැහැර කරනවා. That kind of money is brought into Sri Lanka by you, or taken out of Sri Lanka by you, or you are going to invest such money. If you are using drug dealing, that kind of proceeds of drugs or some proceeds of some other unlawful activity, what you are doing is coming within this limb of the section. So the fact that you entered into a transaction, engaged in a transaction, is what is dealt with in the first limb. Second limb, I'm breaking this section into several parts. This kind of limbs are not would not be seen in the statute. For the benefit of, ease of understanding, I'm breaking it into several parts. Second part is if you are receiving, possessing, concealing, disposing of, or bringing into Sri Lanka, or taking out of Sri Lanka, or investing in Sri Lanka, this kind of a property. What kind of property? A property which has been derived or realized directly or indirectly from an unlawful activity or from the proceeds of an unlawful activity, then again, you are coming within the persons who are doing money laundering, right? Now, I told you earlier just 2 minutes ago, that if there is a drug dealer who has a luxury vehicle and you are going to buy that vehicle, the fact that you bought that vehicle is going to be an offense under these circumstances, right? The fact that you received money from a drug dealer for some other transaction uh, may amount to an offense. Now, is that reasonable? Can someone tell me? Now, you are going to say, this is Saturday, now tomorrow, Sunday morning. You will go through, I don't know, these days the newspapers are available. Okay, you go through some internet website where vehicles are advertised to be for sale. You see that there's a good vehicle that you are looking for, right? You see that price is also very reasonable in the current environment. You are going to buy that vehicle. You call the number given in the advertisement. You find that there's a very nice gentleman talking to you over the phone who is ready to sell that vehicle, and you are asking for a kind of a price reduction, a discount. He is ready to give that as well. So you, in the afternoon, you go there and probably check the vehicle and sign whatever transfer papers, MT6 or whatever, and you get the vehicle. But there can be a situation where the person who has advertised it and the person who sold the vehicle to you is a drug dealer. He has got that vehicle entirely from his drug money, right? So what he has done is he has been in possession of a property which has been derived or realized from an unlawful activity. He has owned that and he has transferred that to you. Now you have engaged in a transaction concerning a property which has been derived or realized from an unlawful activity, right? So you are coming within the first limb, and now you received that property and you are possessing that property, right? Now circumstances are such that you can be sued for money laundering. Can someone tell me that whether this approach is reasonable? You were very unsuspecting, innocent person. Just look at the newspaper and try to buy a vehicle, right? What is the protection to you? We'll start talking. Someone, please. Camera can have mic with right? Okay. Can someone tell me, is that approach okay?
The transaction was done in good faith without any intention of wrongdoing.
Yeah. Yes. I think that can be a very good defense or kind of a explanation. In fact, with that, in this context, you may not be committing an offense. I'll go into that area. Good faith. Oh, you didn't know that, right? There are offenses in criminal law which can be classified into several groups looking at this knowledge and intention part. I think your answer is correct. We'll go into this slide further and see how we can explain it. Now you see that I told you of a person who engages in a transaction with regard to a property derived from an unlawful activity. Or he has received or in possession of or disposes of, brings it to Sri Lanka or takes out of Sri Lanka that kind of property which has been derived or realized from an unlawful activity or from the proceeds of an unlawful activity. Now that person has done that in this context. See, knowing or having reason to believe that such property is derived or realized directly or indirectly from any unlawful activity or from the proceeds of any unlawful activity, right? So you have engaged in that transaction, you have received and you are now in the possession of that vehicle of a drug dealer, knowing or having reason to believe that such property is derived or realized directly or indirectly from an unlawful activity. If you are aware of, if you know, or if you have reasons to believe that it was that kind of a drug property, I would say simply, basically covering all the properties that could have been derived from an unlawful activity, then what you are doing is money laundering, shall be guilty of an offense of money laundering and shall on conviction, then it goes on to the punishment, right? Uh, so that is answer. If you have done something knowing or having reasons to believe that this is a property derived from an unlawful activity, you are committing the offense of money laundering. Generally, otherwise, you are not committing an offense because you don't have the knowledge. You are a very unsuspecting, innocent person who just looked at the newspaper in the newspaper and got a vehicle. There is no reason why. I mean, justice does not. Uh, Justice demands that you should not be punished for that innocent action of yours. But the problem is, as I told you, that in Sri Lanka and in other countries as well, there are certain offenses which need to have the mental component, mens rea, uh, should be there. If there is no mens rea, mental component is not there, you can't commit that particular offense will not be committed. Now, uh, one cannot be basically found guilty for homicide, murder, if the intention is not there, right? But there are certain other offenses where intention is not essential. What is required is knowledge. With the knowledge of something, you are doing something, then that might amount to an offense. I'll take something close to you as bankers, probably, say, Debt Recovery Act. Now, Section 25 of the Debt Recovery Act has a provision to say that any person who draws a check, right, who draws a check, knowing that he does not have sufficient balance to honor the check, commits an offense. So you may be writing a check, you may be drawing a check, not knowing that you don't have funds. For some reason, bank has deducted the particular amount for something, and therefore you don't have sufficient funds in the account when the check comes to the paying bank. That for that reason, check might get returned. Since you are not aware of that fact, you are not committing an offense. But if you had the knowledge that I don't have money in the account, but knowing that you issue a check to somebody, then you are committing that offense because you had the knowledge. Now here it is something like that. If you have engaged in that transaction pertaining to a property derived from an unlawful activity, or if you have received or possessed or whatever, taken it to Sri Lanka or brought out of Sri Lanka or invested in that property, knowing that it was a property derived from an unlawful activity, then you are committing the offense called money laundering. Or if you have reasons to believe that it is a thing that can be attributed to proceeds of crime, proceeds of an unlawful activity. Something like this, you know that your neighbor is a drug dealer. You know that he has been arrested by the police and he has been remanded for some time. And normally big scale drug dealers don't get arrested, right? That kind of a person. Now he is a drug dealer. You know that. You know that he doesn't have any other income, right? That is kind of, one would say, knowledge, but at least you have reasons to believe that this must be derived from an unlawful activity. If there is someone who is not doing any kind of an employment, profession, vocation, anything like that, but has a lot of money, and you know that several times police has raided his place, you have at least reasons to believe that property has been derived from unlawful activity. No, with that reasonable belief, you have reasons to believe that this property cannot be obtained from an unlawful lawful thing. It should have been coming from something unlawful. That it's very gray area. If that kind of knowledge or reasons are there, then you are committing the offense. But as you said, as you answered, the if you are a totally innocent person, the stranger who is just buying something over the internet or based on a newspaper advertisement, not knowing the origin of the property, the how the proceeds have come to purchase that property for the original owner, then you are not committing the offense of money laundering, right? So you see that money laundering is defined here. It is an offense which require the knowledge on the part of the person uh, doing that, right? Any questions on that?
So, small question.
Yeah,
Now, if a innocent person buys such a property
yeah,
without knowing, and now if now somehow or another the authorities will get to know about it, no?
yeah.
So, what happens to the ownership of that property? Will the government take it back for?
Um, it can be, I mean, decided in a lot of different ways. It may be as same as uh, the how properties are dealt with in other criminal activities, but it is possible that that kind of property is confiscated, meaning that government might get the ownership of that kind of property. Uh, all right.
Thank you, sir.
I'll go into certain different aspects as well. Are there any questions on that area again? Is there any question on
Hello.
that? Yeah. Yes.
Yes, sir. So the same concerns a bit of different, but we know that if any transactions happening in the banking or finance sector, of course we have the mechanism to identify the unlawful activities. So we have the anti-money laundering policies and everything, all the screenings. But if the person, that normal person in this example, if someone wants to buy a vehicle, so how this person can be if he committed to uh, support for a money laundering activity in by for buying that vehicle, that person can be under a offense, right, from the regulatory bodies. So in that case, how that person can take this vehicle in a legal manner, sir? So because we don't have normally, as an example, normal life example, when we are buying a vehicle, we are not actually, to be honest, we are not checking all the background and everything, how the seller took that vehicle and everything. So in that case, how we can identify and how that person can be safe on that in this regard?
Yeah, I think you asked the earlier question in a different way, and what you are basically asking, the answer I gave is, if the property is the subject matter of a crime, the person who has bought the property also was under the wa- was in the knowledge, had the knowledge that it was a unlawful kind of a the property derived from an unlawful activity, and in those circumstances, sorry, property could be confiscated. But the difference is, you're asking, there may be a bona fide buyer who has bought the property without knowing that it was something related to a crime, and whether his interests are protected. Of course, yes. One thing that I need to tell you, that I'm taking this example of a particular person buying a vehicle, buying a property, is some sort of a exaggeration, because then only that I can convey this message. Even however much I say that a bank might commit this offense, that might not go into your minds very easily. But this is some kind of a real life thing. This is possible, but in general context, normally a person who has bought a vehicle like this would never be tried under money laundering act. But your question is reasonable. If he is a bona fide buyer, uh, not knowing anything about this offense, his transaction is not going to be nullified and vehicle is not going to be confiscated. That kind of general assurance is always there, uh, right? What I meant earlier about confiscation is that if the property is really, if the transaction really a money laundering transaction, knowing something, if someone has got it, uh, it would be confiscated, right? I'll describe certain things now. I'm taking this vehicle example, which can be related to a lot of you, every one of you. uh, Otherwise, I'll show you how it, what the way outs are as well, right? uh, not that everyone goes into jail for buying vehicles over the internet, uh, or going by newspaper advertisements. uh, did I give a reasonable answer? Sure.
Yes, sir. Thank you.
Yeah, I'll go into details.
So in the case of a financial institution, if
Yeah.
the financial institution has done their their transaction due diligence, got all the evidence and all that, and still if subsequently after a few years it is found that this is proceeds of money laundering, still would and the financial institution has proof to show that they have done their due diligence, would the property still be uh, confiscated, or I mean some kind of action taken against the subject property?
No, not necessarily. I think you asked that question, or your answer content question, the question content answer as well. Now, financial institutions are very complex, large organizations. It does not mean that in that context you can't reasonably expect the entire institution as kind of institutional knowledge, and each of the employees of the institution to have the same knowledge as to what the particular person is doing, and all the transaction of the customer. But if the institution has done reasonable diligence, CDD, on the customer, and has done all reasonable things, including if there is a suspicion, if the institution has reported the position under a STR, there would not be any kind of harm to the institution. I remember when 2006, uh, in 2006, when these two statutes came in, a lot of people were in kind of a reasonable fear as to whether they would be in trouble just by doing reasonable banking business. And a lot of people came to seek guidance, and we went to certain banking institutions and told the board of directors and so on, this is how it's going to work. I remember at one of those sessions, someone told me, that was at the, I think, some securities market related thing. Someone told me, that is a lawyer, that the the way that they wish to go forward is that it was an over kind of exaggeration. What he said was that he would he would report each and every customer who is dealing with them, right? You'll see this is not the way to handle it, but you'll see the answer there. Now what he said was, I would report all the customers doing transactions with us, because I don't know whether that person is doing some lawful business or unlawful business. So for me to get rid of any liability coming from this law, what I should do is I would report all the customers. I would send suspicious transactions reports like telephone directories. That's what he said. Now that kind of reckless approach is not encouraged. I mean, that has a lot of, that is not tolerated, that is not happening. But what you see, the answer is there. If the institution reports the person, wherever there is a suspicion, institution is not going to, your mic is on, and yeah, right, I'll go ahead. If the institution is reporting the person, or if the institution has any kind of a suspicion, institution is will never be in trouble, right? I mean, the impact of anti-money laundering transactions would be felt by a banking institution or a financial institution from the regulatory perspective, only if that institution has not followed necessary safeguards, and if the institution has been negligent, or maybe isolated incidents where certain employees may have kind of had some sort of a connivance with the wrongdoers. Unless that kind of a thing is there, the institutions are not going to be held responsible. Is that clear?
Yes, sir, that is clear. But that is if the financial institution sees a suspicion and reports an
Yes.
STR. But what if they do their transaction due diligence? They get documents for the source of funds, purpose of transaction, everything, and because of based on that, they don't see it as suspicious, and hence they don't report an STR. Because if we
Yeah.
report every customer, it will come under offensive reporting, sir.
Yeah.
So
Yeah.
what
Yeah.
we actually don't see a suspicion, so we don't report it. But
Yeah.
subsequently, later in the day, it's found to be proceeds of
Crime.
money laundering.
Yeah. 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 Of course, you are still protected because you remember, any person who has who having reasons to believe, having the knowledge or having reasons to believe, if they have done that, they are committing the offense. But here it is a clear situation where you have done your CDD and you are clear that this person is doing genuine business with you. Under those circumstances, you don't have knowledge of that person's unlawful activity, or you don't have reasons to believe that he is doing something wrong. But in under any circumstances, there can be certain parties doing unlawful activities without the knowledge of the financial institution. In those circumstances, institution has no responsibility, or I mean, it's not going to face any kind of criminal consequences for just doing business with that person. That's very sure, 100% sure, right?
Thank you, sir.
So,
Yeah.
related to that question, so of course, we are doing all the due diligence when the customer is onboarding. But as
Yes.
a bank or a finance sector, we do have to do the periodic reviews as well when the until the customer onboard to the company. So
Even after the
not that.
even after.
Yeah, even after, yes, even
Yeah.
after as well. So, not that company is guilty on this, or let's say it's a after that, as per the question, after that we have found out it's a guilty unlawful activity. So, in that case, bank also have a
Yeah, yeah, I didn't hear the last part.
responsible to do the
Yeah,
periodic reviews
yeah.
to CDD, and to have any responsibility on this.
I think what was the question is again related. I believe what you're asking is the bank has a duty to do CDD, and it is supposed to do continuous KYC CDD as well from time to time.
KYC,
And
CDD.
yeah,
Yeah.
and also you do that and
So, if the
having
customer, yes,
yeah, please go ahead.
no, if we are doing periodic reviews, so at some point we can identify if the person is doing an unlawful activity. So in that case, if you fail to do the, because if some banks or the finance sectors can be do the CDD when the customer is onboarding only, but not the periodic reviews. So in that case, bank also have a responsibility and guilty of not following the rules, right? Policies, CDD, and guidelines. So in that case, bank has to, the bank or the finance sector has to be under fine, right?
Yeah, I think what you are saying is again, uh, bank may have done proper CDD when the customer is onboarding. After that, also bank may have done continuous CDD in certain cases. In certain cases, certain banks may not have done it properly. Now, of in that kind of environment, if the customer is supposed to have used his drug money in your organization, or unlawful property has been brought into your organization, whether in these two alternative circumstances, one has done continuous CDD, one has not done. what would be the responsibility of the institution. Now, the responsibility of the institution, I mean, if you have done continuous supervision, continuous CDD, and taken all precautionary measures, there won't be any kind of responsibility on you. After doing all that kind of things, there can be exceptional cases which you can't identify. You are not detectives, you are not doing kind of criminal investigations, you are dealing with financial sector customers. If you have exercised reasonable care expected of a banking institution with regard to that kind of a customer, I don't think that you are doing anything wrong, because you are not detectives. You cannot be going into very fine details and doing investigations of a customer, kind of a criminal investigator. That is not your duty. Probably if there was a suspicion, you would have reported that. That's it. Or else you have done your CDD part well. So there won't be any responsibility on you. The other scenario that you were referring to is that they may have done the CDD at the entry point, and after that it's little lethargy. They didn't go into details and did it continuously. So the customer happens to be a criminal, and he's bringing criminal money. Now, that doesn't necessarily mean that bank is doing money laundering, right? Bank has been negligent, that's true. But if the bank had knowledge and reasons to believe that this is drug money, bank and officers would have been held responsible for money laundering as well. But in this situation, if the bank has done CDD and later on has been little negligent and not done CDD, that does not necessarily mean that bank is committing anti-money laundering. Sorry, money laundering. There, the penalties coming to the bank would be from a different perspective. And FTRA, when the responsibilities on the bank is not fulfilled properly, FIU would be imposing penalties. That's not for committing money laundering, but for failing to comply with administrative requirements imposed by the FIU. These are two different things, right? Committing the offense of money laundering is a very serious thing, where you can be directly, I mean, one can be sent to jail. But the failure to do whatever the prescribed activities with regard to KYC CDD is not an offense in that sense. It will entail certain penalties and so on. Naming and shaming will be there. There will be press statements saying that this bank has not done that, therefore we issued a penalty. That kind of things can be there. Did I distinguish between the two scenarios correctly?
Yes, sir. Thank you.
Right. Okay. I'll go into this section. So one can be one who is found guilty of money laundering can be punished with a fine or imprisonment of and even with both. Uh, the unlawful activities identified in the Prevention of Money Laundering Act are, there is a long list which includes these things. Any offense means any includes an poisons, opium, and dangerous drugs ordinance, and in law related to prevention of and suppression of terrorism, bribery act, firearms ordinance, explosives ordinance, and offensive weapons ordinance, exchange control act, or any rule or order regulation issued thereunder. These are the predicate offences identified in Sri Lanka. In addition, offences under Section 83C of the Banking Act. These are, pyramid schemes are covered under Section 83C. Law relating to transnational organized crime, law relating to cyber crimes, law relating to offences against children, trafficking or smuggling of persons, human smuggling. There are some other things, customs ordinance, offences under the customs ordinance, right? Excise ordinance, payment devices frauds act, and National Environmental Act as well is also there. an offense under any written law for the time being in force, which is punishable by death or with the imprisonment of a term 5 years or more. This is kind of an important provision, because now you see that there is a list of activities given earlier. Now, those list of activities are specific offenses under this law. If you have done something that is the unlawful activity for the purpose of Prevention of Money Laundering Act. But this first point in this slide is kind of a catch-all provision, which says that if you have done anything which is an offense under any written law, which can be punished with the death sentence or imprisonment of more than 5 years, right? 5 years or more, then that is an unlawful activity. So there are a lot of offences in Sri Lanka's criminal statutes which brought in, which entail imprisonments of more than 5 years. All those offences are unlawful activities for the purpose of Prevention of Money Laundering Act, right? There are certain few other points given here. An act committed within any jurisdiction outside Sri Lanka, probably outside Sri Lanka, which would either constitute an offence in that jurisdiction, or which would, if committed in Sri Lanka, amount to an unlawful activity within the meaning of this act. That again is an unlawful activity. Probably, if someone has done something abroad, if that is offence in that country, which would, if committed in Sri Lanka, amount to an unlawful activity within the meaning of this act. That again is unlawful activity. Now, I'll tell you one other practical difficulty in this statute. Going into Sri Lanka's legal system in general. Now, may I ask you a question? Now, this, I explained this as a criminal activity, criminal kind of related legislation. I told you that there are two offenses sometimes connected here, very often, in all the cases. There is an offense coming under coming as a predicate offense, then this money laundering offense. Someone has sold drugs and got money, and using that money done certain transactions. So drug trafficking is an offense. The second set of transactions, which would form money laundering, is also an offense. If someone has killed somebody for a payment and used that money to do certain transactions, that killing of a person is an offense. Then again, using that money in a particular way is an offense called money laundering. So there can be a lot of things. When it comes to crimes, what is the standard in Sri Lanka? To what extent someone should prove that, and who should prove that? And what is the situation about a person who is reported to have done some crime? Now, say if A is accused of killing B, right? A is accused of killing B. Now B is no more, right? A is accused of killing B. Now, what should be the situation when he is brought into a courthouse to try his case? Should he prove that he did not kill B, or someone else should prove that he killed B? I'll ask that question again. A has killed B. When A is brought into a courthouse, should A prove that he did not kill B, or should someone else prove that A killed B? Which one is the correct position? Any guess? A is supposed to have killed B. Now, before a court of law, yeah,
someone else should prove.
Someone else should prove. Yeah, that's correct. In Sri Lanka, we have what is called a presumption of innocence. We don't presume someone to be guilty. That is happening where in uh, TV channels and social media sometimes. Whenever there is a charge, they think that they has done the wrong thing. That's a different thing. But in courthouses, before law, everyone is presumed to be innocent until the offense is proved. Right? A person who has been brought into a courthouse is presumed to be innocent. Someone has to prove his offense. Until such time, he can even keep quiet. There may be a case where someone has killed someone before hundreds of people, but still the accused is presumed to be innocent until such time evidence is adduced and the person is proved to have committed that offense. So we have this thing called presumption of innocence in Sri Lanka. Someone will have to prove the offense. Who is going to be that someone? Who has to prove that? Who will have to prove? We is
An
normally there.
eyewitness.
A witness can come and tell his story to court, but who has the responsibility to prove? Witness doesn't have a responsibility, right? I know that what you are saying is he can support it, prove it, that yes, but who has the responsibility to prove? Prosecutor. Yeah, generally yes, prosecutor. Prosecutor, yeah, it covers everyone. I mean, in lower court it may be the police department. In superior court, when it comes to high court and so on, it has to be the state council or the attorney general will have to prove that. So state, the government mechanism, the prosecutor will have to prove that someone has committed an offense. You see that if that position is there, always, since money laundering is an offense, this has to be proved in that way, right? Again, I'll ask you something which is not normal in your knowledge, but probably someone can tell me. Now, as you said, when there is an allegation or indictment of an offense committed by someone against someone or something, there is a need that offense need to be proved. Offense is not presumed. Presumption is that the person who is accused is innocent. So someone has to prove that. Who has to prove it? Prosecutor will have to prove that. When prosecutor proves that, to what extent it has to be proved? What is the kind of standard of proof expected of the prosecution? මොන තාක් දුරකට ඒක prove කරන්න ඕනද? අපි කලින් කියන එකට කියනවා burden of proof කියලා. Who has the burden? Burden is on the prosecution to prove. To what extent? What is the standard of proof? You have heard of two terms, probably. I'll give you them. Balance of probabilities is one kind of a very well-known kind of a standard of proof. Balance of probabilities would mean that when you look at evidence, someone says something, someone else says something, and it is possible that this can happen and this can also happen, right? So you look at the balance and see what is more probable. That is balance of probabilities, right? So can I quantify කරන්න හැදුවොත්, since we are bankers, probably now if it is 50-50, you can't say whether it's right or wrong, right? But if someone has more evidence than other party, say 60-40, then you know balance is towards one particular position. That is what is called balance of probabilities. There is something else, which another standard, which is called beyond reasonable doubt. You need to prove certain things before a court beyond reasonable doubt, right? Beyond reasonable doubt mean that the party who is responsible for proving something has to prove that beyond a reasonable doubt. There cannot be a reasonable doubt as to the position taken by him, right? There can be doubts. It's not, you can't prove anything 100%. There can be minor doubts. That's okay. But if you can prove something beyond reasonable doubt, that is what is expected in certain court cases, right? Now, I told you two different standards. One is that balance of probabilities. The probability, you look at probabilities whether it can happen this way or that way, right? Very possibility එක තියෙන එකට දෙනවා. This is more possible, more probable than the other version, right? That is the proof in certain cases. In certain other cases, beyond reasonable doubt, there cannot be a reasonable doubt. You need to prove that beyond that. එතකොට අර 50-50 තිබිලා 51 වුණු ගමන් දිනන්න බෑ. It has to be a more kind of a clearer way. So what would you think that out of these two, what is more rigorous standard of proof? It is balance of probabilities or beyond reasonable doubt? Which is stricter? I think that I made it clearly. I mean, balance of probabilities is you look at the probabilities and see what is more probable, right? If there are two versions or several versions. Beyond reasonable doubt is that you need to prove that beyond a particular point where there cannot be a reasonable doubt as to whether this happened or not. Which one of these two is more stricter, kind of more rigorous kind of the proof? Anyone? This is not banking though, I know, but
I think beyond reasonable doubt
Beyond
is
reasonable
more
doubt.
specific than the
Yeah.
other.
I think you all are kind of unanimous. Apparently, beyond reasonable doubt is the stronger kind of a stricter, more kind of ambitious way of proving something. You go to such an extent that you need to prove something beyond reasonable doubt. There cannot be a reasonable doubt as to whether someone has done this or not. That is a stricter proof. In Sri Lanka's legal system and in many countries, these two standards are applied in criminal and civil activities, civil litigation. One standard is applicable in criminal, the other one is applicable in civil. Now, I don't want to discuss civil things like, say, debt recovery or a mortgage action or partition action, land case. Those are civil matters, right? Now, today we are talking about a financial aspect in, a criminal aspect in financial world, that is money laundering. Since it is criminal, I would ask the simple question. In criminal litigation, which we are discussing today, what can be the standard of proof? It is balance of probabilities or beyond reasonable doubt. In other words, in criminal litigation, what is the standard proof? The much more stricter one, that is beyond reasonable doubt, or the other one, balance of probabilities. Anyone? Any idea? Again, it can be a guess, but I know that your guess earlier was kind of unanimous, right? Just think of the nature. What should be much more stricter? In criminal litigation, you are dealing with certain aspects. In civil litigation, you are dealing with certain other aspects. Where should be the stricter requirement? I'll tell you this. Let's say I will take a land case. You are having a dispute with your neighbor where the boundary wall should be. That's case number one, civil case. Case number two, someone is accused of killing someone, right? If that person is proved to have committed the offense, he will end up in jail for the lifetime. Now, your land matter and someone's life. In these two matters, what should be the standard applicable? In the civil matter,
Balance of probability.
civil matter balance of probabilities, and uh, in the criminal matter, of course, the other one,
Beyond reasonable doubt. Yes.
beyond reasonable doubt. That is reasonable. That approach is in a way reasonable because you are dealing with someone's life, someone's freedom. One might end up in jail, one might be fined, and things like that. But when it comes to civil matter, it may be millions of rupees, but it's something different. So it's not concerning someone's life as such. So in civil matters, it's civil balance of probabilities. In criminal matters, uh, beyond reasonable doubt. For those who are interested, there are certain circumstances where certain standards in between these two things are also employed in certain specific litigations. But here, generally, in criminal law, the accused is presumed to be innocent until offense is proved by the prosecutor beyond a reasonable doubt. Right? You see, accused is presumed to be innocent uh, until he is proved to have committed the offense. Who has to do that? Prosecution will have to do that. To what extent? Beyond a reasonable doubt. Now you see that it's not an easy task. It's kind of a difficult task when it comes to complicated financial world. Proving all these things that someone has committed this offense and got some money and then using that money done these transactions. If you are to prove all these things by way of in the process of a criminal action, adducing evidence before beyond reasonable doubt, it's going to be a very difficult task, right? So when we were drafting this law in 2005 and before, we thought of having this kind of a provision. Let's look at this provision, section 4. But since it will take some time, I'll explain this. What this law, what this provision says is that I'll put it in a simple way, words rather than going through the statutory words. What it says is that if someone has properties which cannot be part of his non-income or receipts, or income he is known money to which his non-income or receipts has so had been converted. Meaning that I'll give you a practice example in total different way. Now say okay, I won't take anyone else as an example. I'll take myself as an example. I may have told you in the first session, I was working with the, I have been working with the central bank for last 20 odd years, 21 years in fact, right? So I have been with the central bank for last 21 years. I have got central bank's payments, salary and everything from the central bank for last 21 years. And you know that with that kind of employment, I can earn something. In addition to that, I may have done certain things which might bring in an income, because my collection, salaries and savings may have gone into an account, and that account may have produced some interest. I may have used that. I may have bought certain properties and so on. These things can be there. So you know that this kind of a person can have this kind of assets and savings probably. But if you want to quantify it, what he has earned from his non-sources of income, you can do that. You check with the central bank if you have authority to see what is the salary I have earned throughout this period from year 2000 me what has been given to me as my salary and other payments and so on. You can quantify it. Then you can quantify, uh, say even if just assume that I have saved all that money කන්න බොන්නේ නැතුව ඔක්කොම ඉතුරු කරගෙන ඉඳලා කියලා. එහෙම කරලත් ඔක්කොම ඒ කාලේ තියෙන වැඩිම interest තියෙන account එකේ දැම්මොත් if I have invested that in say the highest interest earning instrument available in the market at those respective times, you can imagine, you can calculate, not imagine, you can calculate what really I have earned up to now. It may be some X amount of money, which cannot be a very big amount of money, given the fact that I'm working as a public servant. I'm in the central bank, and there are a lot of limitations, and so it cannot be a big sum of money. Having noted that it cannot be a big sum of money, you might wonder how I am in the possession of several luxury vehicles and houses. Right? One might wonder how this person is having limited income by way of his employment, but having luxury assets, right? So that's kind of, from any layman's point of view, that is some sort of a gray area. So it is not part of your non-income or receipts of your receipts. If that is the case, this section allows for the purposes of any proceeding under this act, it shall be deemed until the contrary is proved. It shall be deemed until the contrary is proved. What is deemed? It is assumed until the contrary position is proved that if you can't explain your property from where you got this property, that property is presumed to have been derived or realized from an unlawful activity. Say in my example, if I have a lot of assets which are not commensurate with the salary and other payments I have drawn throughout my career, then I can, in a court of law, I can be asked to prove as to how I got those assets. Until such time I prove that this is how I have got these properties, I am presumed to have, my properties presumed to have been obtained from or realized from an unlawful activity. So you'll see what is happening. Is this criminal law in Sri Lanka? Criminal law in Sri Lanka requires you to prove the offense. Person is presumed to be innocent until the offense is proved. That has to be proved beyond reasonable doubt. Now here there's a situation where you have properties apparently beyond your control, beyond your income. So what you are, the legal position is that you are presumed to have obtained all those properties from an unlawful activity unless you can prove otherwise. These are the words. It shall be deemed until the contrary is proved that such property was derived or realized from this kind of thing, right? So now in my example, if I can't prove as to how I got additional assets, that those assets are proved to have taken from unlawful activity. Now this provision, you see that it helps the prosecution to successfully conduct the prosecution, right? Any question or any clarification on that? Any doubt on that provision? Can there be something like that, or even does anyone need clarification on that provision anymore? Apparently no. This provision is to support the prosecution, to conduct the prosecution easily, so that you don't have to prove each and every component of the offense. But if you can prove that this person has lot of assets, lot of money beyond his non-income sources, non-receipts, then it's up to the accused person to prove that I got it from legal sources and not otherwise, and therefore I'm not guilty. That part has to come from the accused person. You see that. Uh, you see why I was dealing with that criminal aspect, criminal procedure, criminal prosecution procedures in detail. Now, this is a clear deviation from the normal criminal uh, prosecution. Criminal prosecution generally expect the prosecution to prove that someone has done something wrong. But in this using this presumption, uh, the accused can be asked to explain as to how he got the property. Uh, we call this a rebuttable presumption because you can rebut this presumption. This presumption can be kind of broken, right? Presumption is that you have got it from unlawful activities. You need to adduce evidence and show, no, I did not get from them from unlawful activity, but it is my legitimate income, right? Uh, uh, when we introduced this provision, I remember those who were advising us those days about enacting this law, especially I remember Ross Dalston from IMF, specifically told us, no, Sri Lanka is a decent country with a very decent legal history. If you include this kind of a provision into law, it will damage Sri Lanka's very clean legislation history, because generally in a civilized country you don't put this kind of things, right? That's what his argument was, because everyone should be presumed innocent until the offense is proven. You should not introduce a presumption of guilty into the law. That was his argument. Our counter argument was that yes, those are very nice to have things, but without this kind of presumptions, probably we might not be able to prove offenses. But anyhow, that this provision came into the law. Probably if someone challenged this before the Supreme Court, the position would have been different. But in the current law, this provision is there. It is not a presumption of innocence, but the other way around, right? But what I want to tell you is that as bankers and financial sector professionals, you need to be very careful, right? Especially those who are dealing with money and money-related things need to be very careful. The criminal law is not on your side. Generally, law is on your side when it says that everyone is presumed to be innocent until the offense is proven. But you see that the things that we are dealing with is very complex, and in that complexity might brought in unnecessary unintended results. So you need to be very careful, even ordinarily, in handling finance related things, right? If you have any question on the presumption, I can explain, or else I'll go into other things. Now this one again has a reference to requirement that any person who believes to have information about this kind of thing needs to bring them to the FIU, but I'll go into that when I discuss FDRA. This section, this law includes, I don't want to describe in detail, provisions on divulging information, the ability to obtain issue freezing orders by the FIU, and then how they are get confirmed by High Court. Forfeiture of property, as I mentioned earlier. There are secrecy related provisions as well. Offenses under the money laundering offense is supposed to be a cognizable offense as well as a non-bailable offense. Cognizable would mean that a person who is supposed to have done that can be arrested without a warrant. That is what is meant by cognizable. And non-bailable, it doesn't mean that bail will not be granted, but what it means is that in Sri Lanka there are two categories of offenses called bailable and non-bailable. Bailable means the judge has to give bail, right? Non-bailable would mean judge has a discretion whether to give bail or not to give bail. Now this comes into that category. There are provisions on extradition. Extradition would mean that if a person has committed a crime in another country, in a particular country, and if he's wanted in another country for a prosecution, or else, sorry, if someone is absconding in a particular country after committing a crime in a particular country, if the country where the prosecution is happening wants that person, that country can request the other country to send that person back to this one. That is called extradition. උදාරපණය කියලා අපි සිංහලෙන් කියනවා. Extradition works in terms of relevant international conventions and enabling laws enacted in Sri Lanka in respective countries. Now, this law recognizes money laundering as a extraditable offense, right? You can't get hold of, get people down here from other countries just for committing any crime here. But if someone has done money laundering, that kind of a person could be extradited into Sri Lanka. And also, this is described as not a political offense. Now, this provision, I don't think that it has a significant effect. What it means is that when someone is about to be extradited from a country, those persons can tell the other government, tell the courts of that country that, look here, we are innocent, we are not criminals, we have not done anything wrong, but this particular country wants us because we have done something political, certain political offenses, that's why they want us. Now, in that kind of a situation, the person who is the country where the person is presently residing might refuse to give this person back to the country which is requesting. For example, if a Sri Lankan is living in the UK and government of Sri Lanka is making a request to the government of the UK that that person need to be sent back to Sri Lanka because Sri Lanka is going to prosecute him for an offense, that person can tell the courts in London, in the UK, that, look here, I'm about to be extradited to Sri Lanka, but Sri Lankan government is trying to do something wrong. I have not committed any offense, but I am a political activist. That is, I'll be sued there. That is why they try to take me there. And he can ask the UK courts not to send him to Sri Lanka because he has done something political, not anything criminal, right? So Sri Lanka's law says money laundering is not supposed to be not considered as a political offense. Why I said that this is the operation of this is very doubtful, because now even if Sri Lanka's law says this is not political, the country where the case is heard in the UK or somewhere, they are not bound by this law. So this provision is something redundant. For some reason this went into the law, but it's there, right? Any questions up to that? Any questions? Okay, we'll start at we'll have a small break now, and we'll start at 10:35. We'll start. This is where we discussed the Prevention of Money Laundering Act, and we can go on to Convention for the Suppression of Financing of Terrorism Act. As I told you that I would not be dealing with this law in detail, but just for your information that this was enacted in 2005. In fact, this was initiated by the Minister of Foreign Affairs those days. The drafting team included Dr. Rohan Pereira. He led the team, and this act was amended in 2011 as well as in 2013. And this is an act, as I mentioned earlier, to give effect to the International Convention on Suppression of Terrorist Financing, adopted by the UN National General Assembly in 1999. This is the provision that makes the international conventions requirement part of Sri Lanka's law, which I don't wish to explain. I'll go into this procedural law, which is Financial Transactions Reporting Act now. Now, this is the law that basically gives life to uh, Prevention of Money Laundering Act and Suppression of Terrorist Financing Act, because this is the law that prescribes the mechanism and so on for the AML CFT regime in Sri Lanka. You'll see that objectives of this law includes collection of data relating to suspicious financial transactions to facilitate the prevention, detection, and investigation, as well as prosecution of the offences of money laundering and terrorist financing. So both those statutes, PMLA as well as convention law, have been covered in this part. To require certain institutions to undertake due diligence measures to combat money laundering and the financing of terrorism. To identify the authority which will be responsible for monitoring activities and matters connected and incidental to those. This act contains several parts. Part 1 giving duties of financial the institutions, and Part 2 institution and other persons. Part 3 powers and functions of financial intelligence unit. Functions of supervisory authority of an institution and auditors. Currency reporting at the border. Offences and liabilities and miscellaneous provisions are covered. This one, section 2, now I don't think that this has a lot of significance, but at the time this law was introduced in 2006, this was much talked about point. This basically prevents banks from opening, operating, and maintaining an account when the holder of that account cannot be identified. Those days we used to have those called numbered accounts and so on, where the account holder is not cannot be identified. Now, with the enactment of this law, that kind of practices came to a kind of a complete end, where since this law prohibits that kind of operations. Now, you cannot have an account where the account holder cannot be verified. The institutional duties are given here. Financial intelligence has the authority to issue rules and regulations on KYC and CDD. The institutions are supposed to maintain and retain records for 6 years from the date of transaction. Now, this 6-year story is something very often misinterpreted. Now, in Sri Lanka, for a long period of time, we had this tradition of keeping records for 6 years. The reason is not something relating to AML and CFT, but it's related to prescription period. Hello. The 6-year period, the customary practice of Sri Lanka in keeping documents for 6 years was something emanating from prescription ordinance, which provides that in respect of a written contract, the case has to be filed within 6 years. So banks, financial institutions, other authorities used to keep documents for 6 years. In addition to that, this is a separate requirement. Now, this law again brought in the requirement that every institution shall maintain records for a period of 6 years. Right? But probably you would know that in Sri Lanka, prescription period of for an offense is not 6 years but 20 years, except for homicide, murder. In respect of other offenses, prescription period is 20 years. That is, if there has been an offense committed somewhere, the law enforcement authorities need to file a case within 20 years. If they are not in a position to file a case in 20 years, within a period of 20 years, the case is prescribed. You can't file a case after 20 years. But if it is a murder, of course, even after 20 years, there is no limit. Right? But here, the documents are supposed to be maintained minimum of 6 years. because financial institutions might have to produce these things in legal proceedings and so on. Duties of institutions further include to conduct ongoing due diligence and scrutiny of the customers. And Section 6 requires them to do mandatory reporting of financial transactions, which we often refer to as cash transaction reports. All cash transaction reports, including uh, electronic fund transfers, need to be reported under this. The current limit is 1 million rupees. It has been always 1 million rupees, if I can remember correct. But the suspicious transaction reports are not necessarily under Section 6, it's under Section 7. Other two categories of reports are coming under this one. And if anyone has done a transaction of rupees 1 million or above, that has to be reported to the FIU. That requirement is there as a cash transaction report. In addition to that, Section 7 imposes a very onerous duty on the institutions to report suspicious transactions. If the reporting institutions have reasonable grounds to suspect that any transaction or attempted transaction may be related to the commission of any offense, that has to be reported. Now, there are operational instructions as to how those things are reported and so on. But basically, those have to be reported. Now, there are provisions applicable to other persons as well. In any event, this Section 9 is there, that's a requirement not to divulge information to other parties. Basically, in this kind of environment, tipping off is supposed to be very wrong and again a criminal activity. Now, if the Financial Intelligence Unit has reported a suspicious transaction pertaining to a particular person, the officers or employees who were involved in that process cannot tip off, cannot give that information, cannot give the fact that they have reported the person or the transaction to anyone else. That would amount to tipping off, which is an offense under this law. That is there to facilitate investigation of crimes under this law. Section 12 deals with protection of persons reporting suspicious transactions, because you know that provisions like Section 77 of the Banking Act, but it recognizes that in terms of any other law, information can be given. Generally, the position is that you cannot divulge information. One might sue you under Banking Act or even under the common law that for violating secrecy. To prevent that kind of a situation, to protect the bankers and persons reporting under this law from that kind of litigation, there are specific provisions to say that no civil, criminal law, disciplinary procedures against any person or this institution could be instituted just because that person has reported transactions under the provisions of the FTRA. This is the protection given to those who are reporting. Appointment of compliance officers. You all know that compliance officers are appointed in banks. There are little stricter requirements introduced from time to time with respect to compliance function and how compliance officers should conduct and what kind of frequencies are applicable. And they are under kind of continuous scrutiny by the regulator to see whether their role is properly performed. I used to be, about a few years back, I used to talk to compliance officers very often to understand their concerns as well as to help them carry out their duty properly. What I very often observed was that in Sri Lanka, most of the compliance officers, as it can be the reasonable case, are very rule-based. Sometimes they are very reluctant to exercise judgment, but rather they would go by rules, thinking that exercising judgment is something bad or something that might expose them into unnecessary troubles. Yeah, that can be the practical situation. So I think the compliance officers in Sri Lanka have a long way to go to have some sort of kind of organic behavior in institutions, so that to understand that the role they are performing is not something against the business, not something against the customers, not something just to keep on reporting mechanically as if they are a computer to the regulator, but they have a very kind of a role which would complement the role performed by the business entity as well as the regulator. Now, that understanding is very often uh, not there, I would say. I know that the compliance people in financial institutions very often complain that business people don't understand their requirement. Business people very often complain that compliance people don't understand business requirement. Uh, this kind of conflict is always between business units and legal as well, right? They don't seem to be having misunderstandings about each other's functions. Now, in the financial sector, since we all are from financial sector and related fields, what I would say is that all these things must be contributing uh, kind of towards a common goal. I think in that process, no one is doing something against the other party, but their roles should be complemented by each other. There should be common understanding that they are working towards common goals, but these differences should be confined to relevant checks and balances. Other than that, it's not that someone is against someone doing business, right? Uh, when I go into powers and functions of the FIU, uh, probably this is a start in 2006 March. This was instituted, established. Uh, it is a coincidence. It's kind of a random thing that financial intelligence unit also uh, kept in the central bank of Sri Lanka. Financial intelligence units in other countries are not necessarily housed within the central banks in those countries, respective countries. There are countries where financial intelligence units are housed in different organizations, probably in the law enforcement arms, police department, sometimes in certain other regulators, sometimes under Justice Ministry, as a standalone institution, and so on. In Sri Lanka, at the time the law was enacted, there was no clear understanding. Central Bank took the initiative to enact the law, but there was no clear understanding as to what should happen. The law says financial intelligence unit has been defined as an institution. There are a lot of things. It can be a government corporation, government institution, a department of the government, or even a department within a public corporation. So finally, in March 2006, the minister issued a gazette notification uh, considering FIU to be a department within the Central Bank of Sri Lanka, which is a public corporation, in other words, right? So central bank is a public corporation. The department under it is the relevant department is the financial intelligence unit. Central bank has several departments. One of them is the financial intelligence unit. When it comes to operational aspects, I need to tell you for your understanding that financial intelligence unit, although it's under the central bank, it does not have kind of close interactions with other departments of the bank. The reason being that financial intelligence unit is supposed to be an independent institution. For example, you know that I function as the director legal of the central bank, but I do not advise the financial intelligence unit in their substantive operations. The reason is that financial intelligence unit is supposed to be accepted to be an independent unit, kind of self-sufficient unit. Self-sufficient as far as substantive matters are concerned, but with regard to other things, resources and other things are provided by the central bank. But their substance is never shared with the other departments of the central bank, right? They function as a separate unit that is to comply with the international requirement that they should be independent, right? You know that Section 15 of the FTRA also imposes a requirement on the regulators to report information. Now, in the course of regulation, the regulatory aspects, say, assume direct bank supervision. finds out something about a particular financial institution, a bank, doing some unlawful activity. So some sort of a suspicion as to certain set of transactions that came across in the process of their bank supervision functions. The director bank supervision is expected to report that to the financial intelligence unit. Similarly, anyone who has any finance company who may be engaging in unlawful activities within the meaning of PMLA or terrorist finance related things could be uh, reported by the Director of Non-Bank Supervision Department. Regulators are supposed to report. Securities and Exchange Commission might report the activities of a stockbroker uh, where there is a suspicion that that particular stockbroker is doing something doubtful, right? Suspicious. Uh, the coverage of the institutions covered by this thing, you'll see that from the very initial point in 2006, licensed commercial banks covered, then specialized banks, finance companies, all by mid 2007, and then in 2008, stockbrokers and insurance companies were covered. You may have seen certain non-finance designated non-finance entities like lawyers and notaries are now supposed to give information. That kind of requirements are forthcoming from time to time. The another aspect is that you'll see that banks, commercial banks as well as specialized banks are covered, finance companies are covered, insurance companies, stockbroker, everyone is covered. The reason is that generally the understanding is that a country's AML CFT framework is as strong as the weakest set of institutions they are having, right? Now, just imagine a situation where we are having all AML CFT related regulations only on licensed banks, commercial banks, and specialized banks. There is a possibility that if we do keep on, if we continue, I mean, confine our regulation to those two categories, people who are really behind unlawful activities, who really want to launder money, will not come to banks. They will go to finance companies. Then we might cover finance companies as well. We take them under our regulatory reach. Then they might not go to banks or finance companies, but they will go to stockbrokers. We need to cover them as well. They might go into some other sector like insurance and invest in large, insurance policies, life insurance policies. So we need to cover insurance institutions as well. Likewise, in any country, financial intelligence unit would keep on covering all possible sectors. Now, recent examples in Sri Lanka would be those non-finance professions like, say, lawyers. If a lawyer who kind of executes a deed on behalf of his clients is not bound to inform details pertaining to the customers, probably all these controls that we are having on banks and finance companies and so on will not be very useful. A customer who has earned drug money might not go to a bank or a finance company thinking that they know that they would report, they would ask questions, they would report them to FIU, but will come to someone else and enter into a transaction to buy large number of properties, say real estate, lands and buildings. Then who should report? The seller and buyer, those parties would not report. Then the possible reporting institution, reporting entity, may be the lawyer who is executing the deed. If he has any suspicion as to the source of income of the buyer, he can report that, right? He is supposed to report that. But this mechanism is not as strong as what is applicable to banks and other financial institutions, but professionals are also supposed to do this. When this requirement is there, if someone has been negligent in doing that, then there may be legal liabilities coming on later. For that reason, professionals are very concerned these days in giving their services. Again, they need to be very careful. The section 15(1)(e) allows the FIU to do examinations through the regulators, meaning that FIU might request direct bank supervision to do a specific examination in a particular bank, or Securities and Exchange Commission may be asked to do a particular examination on one of the stockbrokers. That kind of mechanism is there. They have the ability to refer the matters to law enforcement authorities. That is how, in fact, AML CFT things are prosecuted in Sri Lanka and investigated in Sri Lanka. Section 15(1) and section 16(17), dissemination of information of appropriate domestic and foreign law enforcement authorities about the suspicious transactions and so on. These are little details on them. Conducting training programs, which is happening continuously. Under section 15(2), suspension of transactions, that is, freezing orders are issued and they are extended through the involvement of courts. I want to come to some other area, which is MOUs with government institutional agencies. That is, internally there are a kind of large number of institutions coming to central banks FIU and having MOUs with them. The reason being, there are a lot of other institutions which can help this kind of task. For example, say immigration department, when they are issuing passports and so on, this information, passport numbers are closely connected. National identity cards issuing authority, they need to be closely connected. And recent regulations require kind of electronic fund transfers, remittance services to be coming under this. Now, this is the important area I wanted to specially mention. FIU can enter into a kind of agreements, memorandum of understanding with foreign counterparts. Now, there are a lot of countries with which Sri Lanka has entered into such memoranda of understanding to share information pertaining to financial intelligence. Now, you'll see that this is not a complete list. This is, I think, this list may have been prepared using my earlier slides. There are a lot of countries in which use this kind of information. Now, I was telling you that Central Bank of Sri Lanka's FIU has entered into a large number of MOUs with several countries. The reason is very clear. Now, you see that AML and CFT transactions are not standalone, kind of not limited to a particular country, but these are very often cross-border transactions, meaning that offenses may not be confined to a particular country, but can happen between countries. There can be someone who has done a transaction from Sri Lanka to another country, or starting from that country to this country. Or else there can be situations where people may have committed crimes, committed AML CFT related offenses in a particular country, but living in a different country. For example, you see that there is a lot of concentration of Sri Lankans living in Australia. If you don't have a proper mechanism to deal with the FIU of Australia, which is Austrac, right? Probably we may be failing to ensure AML CFT compliance in Sri Lanka. If someone has done something wrong here and went to Australia and living there, we may not be able to look into their things. Now, since we have an MOU with Austrac, that kind of facilitation is there. Austrac may obtain information from Sri Lanka through FIU Sri Lanka. Similarly, we have that kind of Sri Lankans living in countries like Canada or Japan and Malaysia, uh, these countries would uh, facilitate, and USA, these countries would facilitate sharing of information between two parties. Those countries and Sri Lanka, in subject to their respective laws as well as conditions of the respective memorandum of understanding. Now, this is essential when it comes to this kind of financial crimes, because without that kind of international cooperation, you are not in a position to achieve required results, right? This keeps on growing. A lot of countries are entering into MOU in order to see that uh, their respective citizens are away from unnecessary AML CFT attempts. Now, FIU is also required to arrange and to attend to arrangements to comply with FATF, Financial Action Task Force, as well as Asia Pacific Group and other international institutions' recommendations on LLCFT. You may have seen that during last few years, starting from 2017, Sri Lanka went through a difficult time when we were going into grey list and dark grey list and so on. Now, that kind of a thing would have serious economic impact as well, because when international counterparties, decent counterparties, try to do business in the country, they certainly look at the country's AML CFT compliance level. If the country's position is very doubtful or not very satisfactory, those countries may be having laws to prevent international transactions. Again, when it comes to certain commercial transactions, if our ML CFT position is not good, then financially also those counterparties are affected. Affected in the sense, uh, there would be, for example, if we are supposed to pay interest in certain things, our rates applicable to us would be much higher uh, in view of our AML-CFT position. For these reasons, countries need to be, it's kind of a competitive thing now. As much as we are we are interested in developing our, say, doing business index and certain other international ranking on countries, ranking uh, done in respect of different aspects of activities of countries, we need to be very careful about AML CFT culture as well. It's not something to do with a particular financial institution or their compliance function. As a system, we need to do that, and as a country, we need to go ahead with uh, that, right? So that will bring us to the end of this discussion on AML CFT related things. If you have any questions, I can take them now. Any questions on AML CFT related law? Nothing. We'll go on to next topic then. Anyone having questions on this one? Okay. The other topic I wanted to discuss is again something very relevant to banking and financial sector, but sometimes we discuss them in different contexts, but not in the context of banking and finance. Therefore, I would take you through something about law relating to electronic transactions as well as payment and settlement system act related specific areas. I would share this presentation with you. This is law relating to payment and settlements as well as electronic transactions. And I got these slides yesterday. What I saw was that payment and settlements part has come first, but I would like to take you through electronic transactions part first and then come to payment and settlements, because it's kind of regulatory part dealing with the electronic transactions area. I'll take electronic transactions part first, and even before that, I told you that there are several issues I would like to discuss with you. I'll take them first and then come to Electronic Transactions Act, which might provide answers to those issues raised in the discussion. So I expect you to contribute to these questions, the discussion. Uh, this is not exactly related to electronic transactions, only electronic transactions, but there are certain other things as bankers we need to know. I would like to look at these things and share your views with us, with everyone, so that we can have a fruitful discussion on electronic transactions as well as payment and settlement systems. Look at this one. A corporate customer wishes to issue checks using pre-printed signatures. Is this practice acceptable? Is there sufficient legal coverage for this? And I would ask you to consider that and see whether the recent issues are there in the banking and financial sector, which you can discuss in common without any problem. Can someone tell me? I would like you, if possible, to switch on your cameras as well, because then the discussion is easy. I feel like that I'm talking to human beings. Talking to a computer is very difficult task. Now, this is a question. A corporate customer wishes to issue checks using pre-printed signatures. You know that customer signatures printed on the check. Is this practice acceptable? You know that is happening. What I'm asking is whether this is acceptable, whether there are legal provisions to cover this. Can someone explain? Can your bank issue checkbooks to a customer, checkbooks or whatever form, where customer signature is printed? Does this happen? Do you see checks with customer signature printed on it? Customer signature probably means maybe checks for corporate entities. Authorized signatures are sometimes printed. Is it possible? Can someone explain that? I mean, have you seen checks on which signatures are printed? I think I'm the person who sees checks very rarely. Right? You all may have seen a lot of checks. Maybe you've seen them on a day-to-day basis. Are there checks on which customer signatures are printed? Can someone tell that? Might go a little slowly based on responses. Are signatures printed on checks even rarely? What keeps you away from this discussion? Is it the requirement that you need to switch on the camera? Okay, no, not necessarily switch on the camera. Can someone answer? Do we see checks with signatures pre-printed? Someone says in the message, yes. Can we elaborate? Yeah, yes, there are checks. Can someone explain in what kind of circumstances you see checks with pre-printed signatures? Do you normally get checks with printed signatures or in certain occasions? I wanted to include this part from one of my very early presentations to get you to discuss this. Otherwise, I don't know whether we are getting the correct thing from the discussions we are having. Yeah, the same person tells me that there are instances where this kind of things are issued. Yeah, what are the instances? There are instances where checks issued by organizations, corporations. Yes, you give corporate customers, corporate bodies this facility. Ordinarily, that is given or in specific circumstances.
When the dividends paid for the shares, sir?
Yeah, very often you facilitate it when corporate entities issue their dividend checks. You let them to have their signatures printed. The reason is very practical. I mean, corporate entities are having something like, say, if you take the banks in which you are working, I think number of shareholders may be around 10,000, 12,000, and so on, right? Uh, some banks are having less than that, but generally it's something like 10,000. So if you require some person to put 10,000 signatures, you might have to take that person to hospital after that, or else he would be placed in different signatures. So you get them to print that. My question is that practice acceptable? You'll say yes, that is how you are allowing them to do. Is there any legal provision covering that? Is there any legal provision covering that kind of uh, practices, allowing someone to place signatures electronically? Not electronically, sorry, pre-printed signatures. Is it an electronic signature? I wanted to make this discussion as informal as possible, because that is how we go into practical issues rather than studying the law. Now, you see that when I was discussing the FTRA, I didn't want to describe a lot of provisions because anyone can read them. But when you are required to solve problems, that is not something that you can do by looking at a statute. That is why I wanted to give you some problems like this. Now, that will there be any provision that governs that signature? Can you remember something that we discussed during last 4 weeks about signature? Now, this we are talking about checks. If you go by again by even by topics, we discuss negotiable instruments. In that we discuss bills of exchange. We discuss checks. Now, what is the requirement that talks about signature? Is there any requirement of a signature in the definitions that we discussed earlier? Was there any requirement, any reference to a signature? No? Was there any reference to signature in any of our discussions earlier? Okay. Can you remember the definition of a bill of exchange and a check? Check is supposed to be a bill of exchange uh, drawn on a banker and payable on demand. So we are talking about checks here. It should be a bill of exchange drawn on a banker and payable on demand. When we defined the bills of exchange, we had a clause to say signed by the person giving it, right? It is a unconditional order in writing, addressed by one person to another, signed by the person giving it. So the person giving it need to sign it, right? Check is a bill of exchange. Bill of exchange requires that it be signed by the person giving it. What do you mean by sign? The term signed is defined in section 76 of the Bills of Exchange Ordinance. So signed would include that someone's signature is written by that person or someone else, right? That is a very tricky area in the old law. So someone's signature can be written by that person or person acting in its authority. Now, the word written is also defined in the Bills of Exchange Ordinance to say written includes printed. So your signature on a bill of exchange, and for that matter on a check, can be something written by you or written by someone with your authority. That kind of a thing is facilitated. Now that written part is includes printed. So with your authority, if someone prints your signature on a check leaf, that is as good as your physical signature. That is why in that kind of a situation, uh, if a particular customer is required to issue large number of checks, that is why banks facilitate them to print signatures. Now it's not, don't take it for granted, but you need to examine what is the foundation of this practice, what is the uh, legal rationale for this practice. Are we doing something legal, something acceptable? If something goes wrong, there can be huge repercussions. I remember, since you gave this example of dividend checks, that is the most common situation where this is used. Sometime back, about I think 5-6 years at least ago, more than that, I think about 10 years back, uh, there was a particular customer. That customer was a leasing company. Uh, the leasing company had an account with a particular commercial bank. This leasing company wanted to issue dividends to its shareholders. So they instructed that particular commercial bank to issue pre-printed checks. Now, there were lots of customers who were collecting uh, their dues from this the checks issued by the leasing company. All the checks were pre-printed, signatures were printed. That was there. There was a particular shareholder who got a check for a very small sum of money. If I can remember the amount correct, it was 453 rupees. 453 rupees. This customer was a very, I don't know how to explain. He wanted to have something more. So he got this particular document with a pre-printed signature, check. It's not a normal check leaf. He got this and he scanned the image and changed the amount 453 to 453,000 rupees, right? 453,000 rupees. He presented this uh, doctored document, changed document, fraudulent document, uh, which had the appearance of a pre-printed check by that particular commercial bank on behalf of that particular customer to another bank. He presented it to a particular state bank, and this bank paid 453,000 rupees. No, they presented it to the paying bank, which is the bank which printed the document. They paid 453,000, and later on, they said that it was a mistake, and they wanted the collecting bank to give their difference, which was 452,000 something back, saying that the collecting bank has presented them with the fraudulent check. The original intention was 452,000 and they have paid 453 rupees. They were compelled to pay 453,000. The paying bank realized this when the customer leasing company showed this to them. So there was a dispute between paying banker and the collecting banker as to who should bear the loss. Paying banker's position was that it was something fraudulent. Collecting banker should have been careful because under the CITS system, there are certain responsibilities transferred to the collecting banker. Earlier, under the normal law, there are a lot of responsibilities on the paying banker. Their argument was no. Under the CITS system, we could not recognize that. If it was the collecting banker who had the access to the original document, he should have recognized the fraud. And we are not in a position to recognize when it is presented on the CITS system, because what we are getting is only an image and not the original document. The person who has the original document is the collecting banker. He should have identified that. That was their position. Based on the argument that certain obligations are transferred to the collecting banker in view of certain undertakings presumed by the Payment and Settlement Systems Act. Collecting banker, on the other hand, could have said, yes, we give an undertaking, but that undertaking is limited to something. The undertaking they give is that they are presenting a true and correct, accurate image of the instrument that they have received, that they have collected on behalf of the customer. If the customer has given them a fraudulent document, their undertaking is not that it's a genuine document. What they have presented is true and accurate image of the document that they have received from the customer. That is not a guarantee that the document is correct, right? These two arguments are possible. So I remember both parties spoke to me to get some legal insight into this. Carefully manage the affair. Now, what is your position? What is your response in this situation where two bankers are having a dispute as to who should bear the loss? Ordinarily, who would be asked to bear the loss in this kind of a dispute between two banks? Who could have been held responsible? Any idea? Collecting banker or the paying banker?
Collecting bank.
Yeah, why collecting bank? Any reason?
Because they can see the physical check. They are the one who scrutinize the check.
Yeah, then they were in a position to check the nitty-gritties, check the signature, check whether it's kind of a fraudulent instrument. Yeah, that is reasonable. That argument is reasonable. But in Sri Lanka, very often when banks are having disputes, the real liability decides in peculiar ways. It happened here as well. It was the collecting banker was not prepared to take on the responsibility, and paying banker was also argued that they did not have any kind of way to check whether the amount is based on the image. So both were having dispute. Finally, this amount was 452,000. The difference is something 452,000 plus. So parties are not willing to go to courts because litigation is much more expensive than the amount in question. So as natural in Sri Lanka, the person who suffered was the customer. Customer in the sense that the leasing company could not recover their money. Paying bank was not ready to give their money back. So the customer suffered, and those two banks were not asked to bear, I mean, none of them was ready to bear the loss, right? But what I wanted to say here was printed signatures and printed checks are okay, but this kind of risks are there. We need to know the law to deal with that. Law is that collecting banker has certain responsibilities under the PSSA. I'll deal with them when I go into the presentation. Uh, Next question. You are the collecting banker. Your customer expects physical presentment of check to the paying banker. Is it possible? Or what is the law applicable? Now, you all know that you are in post 2006 area. In 2006 May, we introduced what is called check imaging and truncation system, which is being used by all banks now. Check imaging and truncation is a recognition that uh, in presenting a check for payment to the paying banker in terms of the bills of exchange ordinance, you don't have to pay it physically, present it physically, but instead you can present it electronically as an image, right? Uh, Section 33 of the Payment and Settlement Systems Act enables electronic check presentment. Now, there is a customer of yours who is a peculiar customer. Now he argues with your bank for some reason. Now he has deposited a check with you. He tells you, I don't know whether there are customers like that. He asks you, don't send my check by way of an image. Don't use CITS system to send my check, but you must physically present it for clearance. Physically present it to the clearinghouse so that it goes to the paying bank and I will get the money, right? This is a kind of a peculiar situation, extreme example. But my question is it possible? Can you accede to the request of your customer? Customer is asking you to present the check physically, not electronically. In other words, don't forget about this customer and other things. I'm simply asking is, can you present a check physically in Sri Lanka? Any answer? Can you physically present a check? Can you physically present a check? Can someone answer? Can we physically present a check? Meaning that a customer comes to your bank and deposits his check with you, seeking credit into his account, right? Now you are going to present it to the paying banker. Normally what you do is you send the image, but I'm asking whether you can physically present the check. The reason why I'm taking this question is that very often when we go into electronic banking area and electronic instruments and so on, sometimes you tend to forget the fundamentals. We can use machines, but we don't have to be machines, right? So we need to refresh our origin from time to time. So tell me, can you physically present a check? When we go into law, we can discuss legal provisions, but we need to understand this aspect as well. Can we physically present a check if you get a check from your customer for some reason? Uh,
No, sir. Nowadays, no clearing arrangement for those kind of presentments, sir.
What do you mean? No clearing arrangements means you banks do not have that kind of arrangement, right? Hello.
Just previously, we manually hand over the clearing checks and pay orders like those things. But nowadays, it is on the electronic presentment only, sir.
Yeah. Okay. If yeah, I know this is the practical situation that I know. I appreciate it. But what if your electronic presentment equipment are not working? Say entire CITS system is not working. Then can you fall back onto the physical presentment system under the present law? Right? Your customers are expecting money, but your electronic presentment doesn't work. In that situation, can you go back? I'm concerned in the electronic transaction, sorry, Payment and Settlement Systems Act, Section 33. Section 33 enables you to present the check electronically by way of an electronic check image. It does not prevent any banker in Sri Lanka from presenting a check physically. You might ask, what is the purpose of physical presentment when electronic presentment is there? Yeah, it is there, but you need to understand for this point that it does not prevent. What I want to, the point I want to drive here is that electronic going into electronic means does not necessarily prevent the other way, the physical presentment and so on. Now there are areas where physical transactions are totally stopped or suspended as much as they go into electronic area. But there are a lot of areas where electronic thing is introduced and enabled, but that does not necessarily preclude someone from going into physical environment. So here the answer is it is possible in terms of law. It is possible. Applicable legal provision is Section 33 of the Electronic Transactions Act, which says that someone can do this, but not necessarily someone shall do this, right? So answer is it's possible. Discussion number 3, probably after that we might go into that area, the original discussion. You are the collecting banker. Your customer's check has been dishonored. You are the collecting banker. You collected some customer came and deposited the check, and you presented it electronically, and it has been dishonored by the paying bank. Now your customer wants a check to file a case against the drawer, right? The person who gave him the check, drawer, has now defaulted. That is, a check got dishonored. Now your customer wants check back. The question I'm asking is it possible? Is it necessary? What is the law applicable? Now your customer is asking you to give him the check back, the dishonest check. Is it possible?
No,
Why?
because the check return remark is in check return notifications, CRN, not in the physical check, the check return remark.
Yeah.
So the check return notification as an electronic, the printout is enough to file a case.
Yes. That's correct. Factually correct. I mean, the notification CRN, check return notification is there. That would serve the purpose. Check return notifications, that is the technical word that we are using from 2006, but what the law says it's the term used in the Payment and Settlement Systems Act is Image Return Document, IRD, or CRN, as we commonly call it. CRN shows the details. But where is the check? Why do we call this system check imaging and truncation? CITS. Right? We'll go back to fundamentals. We call this system CITS. Check imaging and truncation system. Okay, we know the meaning of C, check. We know the definition of a check. Check imaging. Imaging. What is imaging? We create an image in this system. Image is sent to the clearinghouse, right? check imaging is clear. And truncation, check imaging and truncation system. What is truncation? Can someone tell me what truncation means? What do you mean by truncation? Any answer? What do you mean by truncation?
So processing it or something like that. Process.
Eh, yeah, uh, it's something a little different. What is it?
It is to make the process quicker.
Uh,
So shortening it.
yeah, it's kind of shortening, or what you mean is that your thing got truncated. Truncated is it was stopped. It was cut off from the process, right? Truncated means it got stopped there, right? It shortened in a way. Process was shortened. How? Process got cut off. Process got stopped. How? You don't send a check anymore. Physical check is not sent. So where is the physical check now? After customer presented it and you send the image, who has the physical check?
So does the receiving bank has the check usually? Actually, no idea about that.
Yeah, collecting bank has a check because customer deposited a check with the collecting bank. Collecting bank is the one who created an image and sent it to the clearinghouse and then to the paying bank. Now, physical check is in the custody of the collecting bank. So collecting bank is in a position to give the check. Is it possible legally? Yes, under section 34, collecting bank can give the check, but there is no need, as you said, as someone said, as there is no need because section 34 subsection 2 says the image return document or CRN shall be deemed to be the check to which it relates. The image return document or CRN shall be deemed to be the check to which it relates. You know this word deemed we used in AML CFT as well. Deem karna, assume karna. The check that CRN is deemed to be the document to which it relates. What does it mean? You deem that this CRN is the check. So you don't have to use the original check, original document to uh, uh, file a litigation. Or for any matter, you don't have to use the original document. You don't have to ask for it. Customer doesn't have to ask for it. You can explain to the customer, no, CRN serves the purpose, right? Then there is this question from your practical point of view, since you're in banks, you can tell me. Now, earlier, when a check is returned, uh, sometimes you get them to present the check again. That check with the endorsement can be represented to the bank uh, to consider in the clearing process once again. Say I draw a check and give it to you. Check get returned for some reason. Then you blame me for returning for not having funds in the account, and then I put some funds and ask you to present it again. Now, how does it happen with the CRN? Can you represent CRN? When the check is returned, you can present the return check once again, right? On the assurance of the other party that funds are available. Now, would it be equally applicable to CRN as well from your practical point of view? Now, can someone present the CRN and say that now I want funds, this is my presentment?
So in that CRN, sometimes it is printed. If it's not representable, I think they have stated it. I have seen such things like in the image on the check return notification.
Yeah,
There is sometimes a stamp is there. It says not represented
yeah,
again.
yeah. In fact, this is the discussion I want. It is there. It is printed there. So it means that in certain circumstances it is not possible. In other circumstances it's possible. So legally it is possible. I mean, if the image return document is the document to which it relates, that is what the law says. So it is possible, but under clearinghouse rules, there are certain circumstances in which a check cannot be represented. Therefore, CRN contains that kind of remark to say, uh, under these circumstances, you can't. Now, generally, you would see that if the check is returned for want of funds, meaning that the other party does not have funds, කොහොමද ඒකට banking terminology එක refer to drawer, right? If the check is returned with the instructions refer to drawer, meaning that the drawer doesn't have funds, uh, then that cannot be represented, right? And several other, there are these different codes for uh, check returns. Under certain circumstances it cannot be represented. uh, Now I'm taking this refer to drawer thing for a particular reason. I don't know whether I'm correct, whether it's the same practice still there. Is it there? Can I refer to drawer kind of the check refuse the return with the not refer to drawer can be represented? Anyone
No.
who it cannot be. It used to be. It. I mean, sometime back it was possible, but it's very hilarious that in 2009 or so, there was a situation where there was a situation where a lot of checks were getting returned. Check return numbers in the country were not very good. There was this concern as to how this is kind of kept under control. Uh, I was asked to understand this problem and solve solve the issue by uh, introducing suitable mechanisms. Uh, One thing I noticed was that the return numbers are too high because of repeated returns. Refer to drawer checks were returned, then the people submit them again get returned. So single check return is recorded on multiple occasions because they are being represented. Now that situation made Sri Lanka's, I mean, the out of the check returns available those days, large number was this kind of re-returns. That was supposed to be something not very good. So we decided to introduce this thing, not to represent the refer to drawer checks. Then I remember those people who were complaining about the problem uh, started complaining again, saying that solution was much more uh, uh, solution was not was again, I mean, worse than the problem they had, because earlier they could have at least collected it on the second go, but this prevents someone from going for a second time. But this is not the only solution. With that, there were several other measures introduced that resulted in Sri Lanka's check returns uh, return numbers going down drastically, right? So this one, it was not a very kind of a thoughtful thing, but that at that time we thought that this number, this ugly picture, could be rectified by this as well. Uh, This number 4, I would deal with that after I did there's a kind of a leftover part on negotiable instruments. After that only, I would go into number 4 here. Now, with this limited discussion, I'll take you to the uh, presentation on electronic transactions and come back to these issues once we do the other parts. This law relating to electronic transactions is not something uh, that we discussed maybe in early 90s and so on. But in 1997, there was this UNCITRAL model law on electronic transactions. UNCITRAL is the United Nations International Conference on Trade Law. UNCITRAL wanted all the countries to have some sort of a commonality in their electronic transactions law so that the world can move ahead with some sort of developed laws in this area. Uh, Ancestral Modulo, it's 1996. It's my mistake. 1996, it was enacted. I remember, if I can remember correct, in 1997, Singapore adopted it based on that model law. They prepared their law. In 1999, India prepared their law based on the ancestral model law. Likewise, it went on. In latter part of 2000, we also had this idea of introducing Electronic Transactions Act in the lines of the model law. But for some reason, there were a lot of kind of uh, uh, issues in the country, and therefore Electronic Transactions Act was not considered a priority until 2006, right? In 2006, number 19 of 2006 was enacted, by which electronic transactions are recognized in Sri Lanka. Now, since I'm going into Payment and Settlement Systems Act as well, I need to relate something here before going into substantive provisions of the law. Now, do you have any idea as to when Sri Lanka introduced its RTGS system and SSSS system, scriptless security settlement system, we collectively call Lanka Settle? Lanka Settle includes RTGS as well as Lanka Secure, right? Any idea as to when Lanka Settle was introduced in Sri Lanka? That is RTGS system plus SSSS. Any idea? I'm trying to connect it to this topic on electronic transactions. Any idea as to when this law was enacted? The RTGS was introduced? Would it be before 2006 or after 2006?
Before.
Before. Yeah, factually it's before. Yeah, it started in 2004. In latter part of 2003, there were arrangements. 2004 was the year in which we started. But what I wanted to relate is that this law, Electronic Transactions Act, came into operation only 2006. What do you mean? Did we have these large value payment systems like RTGS and SSSS without having the proper legal background? Electronic Transactions Act was enacted in 2006, whereas we have had electronic fund transfer systems even prior to that. So this is something you need to understand very carefully. Now, in 2000, when we were trying to introduce this Electronic Transactions Act, when the attempts failed, we were in the process of introducing the RTG system and so on. By 2001, 2, we were in the process. Then we realized that Sri Lanka's Electronic Transactions Act was not forthcoming. Now, in that situation, it was very difficult to introduce an RTG system. So what we thought was, if the country doesn't want that kind of a thing, we cannot wait for the country to enact the law. But we thought of having a provision in our specific law, in the central bank specific law, that is Monetary Law Act, that is the act by which the central bank was established. We were moving an amendment to the Monetary Law Act. In the amendment, we introduced a chapter to deal with RTGS and SSS. What we said was, This kind of systems can be established by the Central Bank of Sri Lanka for the with the in which participants could be the banks and so on. And we said that if a transaction goes through that system, uh, you cannot deny legality, recognition, and enforceability for those transactions. And finality of those transactions are ensured by the Monetary Law Act. Likewise, we provided all these provisions which are now in the Electronic Transactions Act by way of an amendment to the Central Bank Statute, which is the Monetary Law Act. Now, this attempt could not be, objected by anyone else because Central Bank was amending Central Bank Statute. We cannot amend the law. We suggested and we went to the Parliament and got the amendment done because we wanted to have an General Electronic Transactions Act in place, but that was not coming in. There were a lot of political arguments here and there whether we really need this one and whether Sri Lanka is matured enough to handle this kind of law. So we did not want to take part in that discussion. We went ahead with the separate set of amendments and got our amendments passed in year 2002. And by 2003 end, we were ready with the system, right? So you see that Electronic Transactions Act now serves a purpose in the country, but as far as the banking sector is concerned, this was there, this protection, this comfort was there from year 2002. So you need not to be unnecessarily alerted by certain things that you might discuss when I go ahead with the discussion on the Electronic Transactions Act, right? In year 1997, there was an amendment to the evidence law facilitating computer evidence, right? Now, under that environment, in 2002, we had the Monetary Law Act amendment. Then, in 2006, this law came in. What does this law say? It facilitates the formation of contracts, its creation and exchange of data messages, electronic documents, electronic records, and other communications in electronic form. And it provides for licensing of and authorization of certification service providers. I'll go into substantive provisions here. Section 3 says, recognition to data messages, electronic documents, electronic records, and other communications should not be denied legal effect and enforceability merely because it is in electronic form, right? The problem here is that in Sri Lanka, a lot of statutes refer to records, documents, and so on. Now, those things would ordinarily mean only physical documents. So there should be a specific law that enables electronic documents to be included in the definition. Now, this law, Electronic Transactions Act, could apply to all transaction businesses done in electronic form, but there were recognized exceptions, right? This is the place you would be probably will go into. You'll see that electronic transactions, of course, they can be acceptable. They need to be acceptable in certain circumstances, but there are exceptions as well. Now look at these exceptions. The creation of or execution of a will or any other testamentary disposition. If you want to draw a last will, you can't be drawing a last will electronically because these are areas where there would be problems in future. A lot of people will come and say that the person who created the document is no more. Since he is no more, a lot of people can say a lot of things. So the having an electronic document was not supposed to be acceptable as a last will or testamentary disposition because of this risk, right? That is excluded. A license for a telecommunication system, right? If you are having a license for a telecommunication system, that license need to be a paper document. Now, this is since ICTA was instrumental in drafting this law, they thought that the license for a telecommunication system should be in paper form. Now, if you see a particular risk in having a certificate, having a license in soft form, in electronic form, that risk is there in the telecommunication system licenses as well as other licenses. Now, say just about think about the license issued to a commercial bank. Now, according to this law, a license issued to a telecommunication system cannot be in electronic form, but we can issue an electronic license to a bank in that case. Now, this law is very short-sighted. If you are excluding licenses, you could have excluded all the licenses issued by regulatory entities under certain laws. Rather than that, this one limits it to telecommunication system operator's license. Number 3, a bill of exchange as defined in subsection 1 of section 3 of the Bills of Exchange Ordinance. A bill of exchange cannot be issued in electronic form, which we can recognize if you look at the volume of electronic bills of exchange that are used in the country. It would be very difficult if electronic bills of exchange are also drawn in electronic form. Now, that was specifically excluded. For the time being, it's the case, but in future probably these need to be changed. Then this financial matters between these things, these were not there in the original. Some of these were not there in the original act. In 2017, about 4 years back, this act was amended by number 25 of 2017. By that amendment, this part has come in. You see, any financial matter in the nature of the following: transactions on a regulated exchange. On a regulated exchange, if the transactions are done on regulated exchange, those are not governed by these provisions of this law. Say the stock exchange, it's a regulated exchange, regulated by the Securities and Exchange Commission. Transactions are not covered by this law. If the central bank establishes a kind of exchange for government securities, those are not covered by this law. Look at number 2, foreign exchange transactions. The foreign exchange transactions between your bank and the central bank within the banking system, those are not covered by the provisions of this law. Interbank payment systems, right? Interbank payment agreements or clearance and settlement systems related to securities or other financial assets or instruments, those are not covered. So see, RTGS is necessarily interbank payment system. It is not covered by this law now. Then we'll take retail payment system like SLIPS, Sri Lanka Interbank Payment System, is not covered by this law. Now, this is a problematic area. Then the Roman 4 here, repurchase transactions, those are not covered by this law. This is seriously a problematic area for the reason that why do you want to exclude all the banking sector transactions from the application of this act? Banking sector is the sector in this country that would do the large majority of transactions electronically, not anyone else. Now, Sri Lanka is supposed to have given recognition for electronic transactions in the country. But in 2017, that recognition given to electronic transactions of interbank payment system has been withdrawn. That is what is meant by this provision, which says that this act does not apply to this. If the act does not apply to interbank payment systems, SLIPS transactions would not be covered by this. RTGS transactions would not be covered by this. Now, this is kind of a hilarious thing. If all the banking transactions are taken out of the scope of this law, then what else is there to be covered? There may be a very little. If the banking sector transactions are taken out of this, it may be a very little. It may be having a very little scope, right? These things you can identify. A power of attorney. Power of attorney would not be, maybe in present Sri Lanka, it may not be feasible in electronic form. Then trusts, given in terms of trust ordinance, a contract for sale or conveyance of immovable property, or say if you want to buy a land, the land has to be bought by way of a physical deed, no electronic deeds. You see, the, the, the given the level of disputes over lands and buildings in Sri Lanka, it's very risky to have a electronic deed. So it says that it needs to be in paper form. That's okay. But that thing about the banking transactions being excluded is not something one can comprehend. Now that is, I checked this position with the people who were behind this particular amendment, uh, and I was told that this particular amendment, where the banking sector transactions were kept out of the application of the law, were introduced to comply with some international convention on electronic transactions. When I checked that particular convention, yes, convention has a clause to say that countries should prevent, take out their payment, the banking system from the application of their General Electronic Transactions Act. It was a little peculiar for me to see that countries should exclude the banking sector transaction from the application of the General Electronic Transactions Act. Then, since that was not, why should we take out banking sector? Why do we uh, confine it to sectors other than banking? Then, out of curiosity, I checked the background documents to this convention and found that the convention says that the interbank payment system should not be covered by this statute for the reason that interbank payment systems are generally covered by much more strict and clearer laws, and therefore general law of the country should not uh, General Electronic Transactions Act of the country should not cover interbank payment transactions. That is the reasoning. Since the country's banks are having a better legal system, this general thing should not cover that one. What we have done in 2017 is, despite without checking whether Sri Lanka's interbank banking sector is having much more stricter and much more kind of uh, 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 nice laws than this one, we have just kept the limit, introduced the limitation so that banking sector is not covered. Now, are we in real trouble? I would say no, right? We are doing transactions electronically. No one has stopped electronic transactions because of this amendment in 2017. And I would tell you as well that we are in the process of getting this amendment reversed. We have written to that effect. And I think just because this amendment is there, no one has stopped electronic transactions. I'll tell you the example of the RTG system. Now, RTG system is functioning. Now, if someone says Electronic Transactions Act would not apply to it because of this one, I would say yes, it didn't apply even prior to 2006 as well, because this came into operation in 2006. How did we run the RTG system in 2004, 5, and 6 without the Electronic Transactions Act? So even if now it says it is not applicable, now where are we? We are in the situation where we were before 2016. Sorry, 2006. That's not a problem. We have a fallback situation in the Monetary Law Act, which says that these are legally recognized. So we don't have a problem. Slips came into operation, I think, in 1990s, right? 97 or so. Now, slips operations are governed by proper contracts drawn between parties, as well as slips is settled in the RTG system. So there won't be a problem. It is not something that we should be unnecessarily scared of, but something ridiculous. Now, when one authority enacts a law and amends the law, other authorities should also know and should be given an opportunity to work in that area. Now, if without that, since this law has been amended, there is a problem, but it's not going to destroy anything else or the operations in those areas. But this has to be rectified sooner than later, right? Now, in this law, forget about the part that this is not now applicable to the banking sector. Still, we look at what it is. The requirement for write-in shall be deemed to be satisfied if the information, data message, electronic document, electronic record, and other communication in electronic form is accessible so as to be usable for subsequent use. Now, this is basically giving recognition to electronic documents. Things for the requirement of things being in writing. In writing, requirements can be made by keeping documents in the electronic form. Original document requirement can also be covered there. Electronic signatures are recognized in the Electronic Transactions Act. Right? It is as good as your physical signature. That assurance is there. Presently, electronic contracts are also recognized under Electronic Transactions Act. An offer can be made electronically, and acceptance can be made electronically. Therefore, electronic contracts can be formed electronically. That is also recognized. These are very important for the sectors other than interbank payment systems because of the reason I mentioned. Admissibility of e-documents as evidence, that is also given there, subject to a rebuttable presumption. That recognition is given in this law. I'm not going to read this one. There are cases in which electronic documents, electronic evidence have been accepted. Now, these are famous cases in recent Sri Lanka. This Marine Star case where SMS message was admissible as a piece of evidence. This one, MIT versus DPJ Holdings. Contents of a website was submitted as evidence, and computerized accounts ledgers admitted as electronic records in the third case mentioned here concerning People's Leasing Company. So these are happening in Sri Lanka. I mean, these more than in commercial transactions, text messages and emails have been recognized in personal affairs as well. Marriage and divorce related cases also, they are admissible. If the court system admit them, it's a good sign, even without the law. Now, this law particularly recognizes that one, right? That is the background. But payment and settlement system is more specific to the banking and financial sector. We'll go into that topic in detail, probably next week or week after. Probably I might take the class next week, or someone else is likely to take. Anyway, the remaining part of this one, can't say remaining part, but major part, Payment and Settlement Systems Act, will be discussed later. We'll stop here today.